A very good evening to
Very
all of you. Law Essentials welcomes you to the webinar on aviation law. I am Mohammad Faransi, founder at Law Essentials and a student of St. Joseph's College of Law, Bengaluru. Today, we are privileged to have guest speakers. Mr. Syed Tamjeed Ahmad. He is an aviation lawyer at Sarin Co. He graduated from Jamia Millia Islamia and pursued advanced LLM in Air and Space Law from Leiden University. He was an Erasmus Mandamus trainee with Boeing and a public speaker at TEDx. He has a keen interest in aviation finance, leasing, and also in banking and financing. We also have with us Vikrant Pachnanda. He's an advocate on record at the Supreme Court of India and also an aviation attorney. Thank you so much for devoting your precious time for conducting this webinar. We're extremely honored for this opportunity. Here we come to the much awaited event, sir.
very good evening, everyone. The topic that we're discussing here is liability and aviation law. I think that's something very relevant today, especially in the light of the unfortunate Air India Express incident around a week ago, where 18 lives were lost, including of the pilots and several passengers injured. So that would be a topic as to where something like the concept of air carrier liability would fit in. Now, how we Tamjeed and I plan to divide this is that I would be looking into air carrier liability laws prevailing in India, as well as liabilities of air carriers to third parties on the surface, and Tamjeed would be looking into air carrier liability law prevailing internationally, on which the Indian law is based. So to start off with, I will first start off with liability towards third parties on the surface. Now, many of you would wonder what is you mean by liability towards third parties on the surface. Many of you would recall not too long ago we had an unfortunate crash of a Pakistan International Airlines flight where while it was attempting to land, the plane lost altitude and crashed into a few houses just short of the runway. Now, this is why I'm giving you an example is because this example is a recent example and maybe something which is there in all your minds, your memories, to kind of connect the dots with liability towards third parties on the surface. So, therefore, how this topic would be applicable to the PIA crash, before I get into what this topic is about, is that the PIA plane crashed into a cluster of houses and was unable to land. Now, the question arises that aircraft operator, that is PIA, if we look at this example, towards third parties on the surface. Third parties in the context of this um, PIA crash would be the people, the occupants of the homes which got affected because of this crash. Maybe if there were some other people in the vicinity of these houses where this crash took place. So this is what you mean by third parties. And it's called on the surface because the crash did not happen in air. It took place on a surface just before landing. So which is why there's a concept of liability towards third parties on the surface. That is, who would be liable if an air carrier crashes on the surface and of course the passengers are injured, or they may lose their life, for which Tamjeed and I will get into that a bit later. But what about the third parties who are not passengers? So therefore, this topic is apt and would deal with what are the relevant provisions, instruments of international law which deal with this. We have the Rome Convention signed way back in 1952. This lays down the rules for compensation of damage which is sustained by third parties. But it has to be on the territory of a contracting state. And the aircraft should be an aircraft which is registered in a contracting state. So that is very important. So if we take the example of the PIA incident again, Pakistan, the aircraft A has to be registered in Pakistan, which means that it should be in the books of the Civil Aviation Authority in Pakistan, and or the damages are sustained on the territory of a contracting state, which in this case is also Pakistan. And therefore, it would be first important to see whether the state is a contracting state. That is a state which has signed the Rome Convention of 1952. So that is one thing. So that is one aspect. Then the second is the damage must have been caused, of course, like I said, by an aircraft in another contracting state to the Rome Convention. In this case, the country is the same. The aircraft belonged to a country, Pakistan, and the damage was inflicted in Pakistan. So therefore, we would only have to ascertain whether Pakistan would be a contracting state or not. But say if this crash or any other crash occurred, say the PIA crash only, for instance, say if it occurred in another country, any other country, then in that case we would have to not only see whether Pakistan is a registered whether contracting state. Why? Because whether the aircraft is registered in Pakistan or not. Secondly, the country where the crash happened, whether that would be a contracting state or not. So these are two important essentials to see for the Rome Convention to be liable. Then, of course, who is liable under the Rome Convention? The liability under the Rome Convention is to the person who controls navigation of the aircraft. Now, who would control navigation of the aircraft? But obvious, the operator of the aircraft, which again, if we take the PIA example, would be Pakistan International Airlines. So that would be the person who has controlled navigation of the aircraft, and one would ascertain whether PIA is liable or not liable, subject to the conditions I just mentioned. Normally, it is the, as per Article 2 of the Rome Convention, it is the operator of the aircraft that is presumed to be the registered owner of the aircraft. So therefore, unless, of course, proved otherwise, it is presumed that in the PIA's case, unless they could prove that the aircraft was actually registered in another state, Pakistan, PIA is the registered owner of the aircraft over here. And now, of course, another important aspect, like I said earlier, the Rome Convention does not apply to damage inflicted to an aircraft that happens mid-air. So you have to be on the surface, which is why I've given the example of PIA, because that was a crash that took place on the surface. Any liability that would arise would be because of this crash towards a third party on the surface. And it would had this crash taken place mid-air, the Rome Convention would not be applicable. This we get from Article 24 of the Rome Convention. Of course, akin to the Warsaw Convention, which Tamjeed will deal later during the course of this presentation in, the liability of the otherwise liable person can be annulled in case there's a contributory negligence of the victim, that is the third party on the ground. For instance, if there was say for instance, the plane was to crash into a petrol pump, and say one of the persons filling fuel in the vehicle was also smoking, which is anyway prohibited in a petrol pump. So anyway, the petrol pump is there's a threat of the petrol pump anyway catching fire, and immediately if you have an aircraft which has got reserve fuel loaded for 2-3 hours to fly in case it can't land and it crashes, the ignition would definitely be more. So we could try and bring a case of contributory negligence in such a scenario, and liability of the otherwise liable person, that is Pakistan, if at all the other criteria met, could be annulled if we are able to prove this contributory negligence. Now, Articles 1.1 and 2.1 of the Rome Convention are very, very clear. I repeat, 1.1 and 2.1, that any person who can prove that the damage to him or his property was caused by the aircraft in flight or by any person falling from that aircraft is entitled to compensation from the operator of the aircraft in question. So therefore, if meets the requirements of, the requirements are met of applicability of the Rome Convention to PIA, as per the provisions I said earlier in my presentation, any of the people who are who were there on the surface, or their properties, that is their houses, which were damaged because of the aircraft, which it was in flight and it crashed, so that would qualify, is entitled to compensation from the operator of the aircraft, which would be Pakistan International Airlines. Then of course, so therefore, what are the ingredients? Article 1.1 ingredients are very clear. Third party is the one who's the victim. He's the one who would be the plaintiff in the suit that he files, and he has to only state two things. Number one, he has suffered damage. Number two, that this damage was caused by an aircraft in flight. So therefore, damage suffered and this damage caused by an aircraft in flight. Once this is proved, then next we are certain whether this aircraft is registered in a contracting state, and whether this third surface comes within the territorial jurisdiction of a territory which is a contracting state to the Rome Convention. If that happens, Rome Convention is applicable and the operator of the aircraft is liable. So that sums up liability towards third parties on the surface. Now I move on to the next leg of my presentation, and that is air carrier liability law prevailing in India. Now again here, before I start off, an apt example which I mentioned before the PIA example was the Air India Express crash. Now, by the way, we could also attribute maybe Air India Express, we could have attributed Air India Express to third party, because it did slide down the runway, but there was no third parties, I believe, from what we read on the paper around. But of course, if that was the case, that could also fit into that. Coming back to air carrier liability law prevailing in India now. So the Air India Express crash obviously opens up a whole new litigation as to will the air carrier, that is Air India Express, be liable to the passengers. 18 lives were lost, including their own pilots, and several others were injured. And injured again, not just physically, but many of them mentally traumatized. Which also comes within the ambit of accident within Article 17 of the Warsaw Convention, which Tamjeed will get into. So the question arises as to how do we look at air carrier liability law prevailing in India? Now, I'm just going to give one line on the international aspect, and then I'll leave the rest of that for Tamjeed to deal with. But primarily, there are two conventions. We have the Warsaw Convention, which set out air carrier liability law, and India signed that. And thereafter, we had the Montreal Convention, which came subsequently. And Montreal Convention is applicable to countries who have signed both the Montreal and the Warsaw Convention, or only the Montreal Convention, whereas Warsaw Convention is applicable to those who have signed the Warsaw Convention but not signed the Montreal Convention. India has signed both the conventions, and accordingly, in 2009, the Montreal Convention came in 1999. It took India 10 years, but in 2009, India thereafter amended the air carrier liability law. This air carrier liability law basically is based on its international treaty obligations under Article 253 of the Constitution to enact a domestic law to fulfill its international treaty obligations. These international treaty obligations are the Warsaw Convention, which India signed initially and thereafter followed by the Montreal Convention. Therefore, in consonance with the same, India first came up with the Carriage by Air Act in 1972, and thereafter, when the Montreal Convention came, this act was amended in 2009. Now, the Carriage by Air Act sets out a limit up to which a carrier can be absolutely liable for A, damage, B, death, and 3, bodily injury sustained in the course of air travel on board a carrier and during the course of any operations of embarking/disembarking in context to a passenger. So now I'm going to break the sentence up. A carrier can be absolutely liable for 3 things. One is damage, and damage in particular means damage to baggage, death, and bodily injury. This has to be sustained either during the course of air travel when the flight is airborne, or it could also be during the course of embarking or disembarking. Now, embarking would be when you begin the procedure to board an aircraft. Disembarking would be a procedure that is when you're disembarking from the aircraft. So you could be, say, on the staircases of an aircraft, boarding or disembarking. And, the staircases move when you fall off. The Carriage by Air Act would apply there, and so would these international conventions, Montreal or the Warsaw. Now, what I just said, you find in Section 17 of the Carriage by Air Act. Now, Section 5 of this Act establishes the liability of a carrier if there is a death of a passenger during the course of carriage by air, and these are subject to rules which are contained in 3 schedules in this Carriage by Air Act. One could be the first schedule, one could be the second schedule, third could be the third schedule. Now, what are these different schedules? The first schedule basically harmonizes provisions of the Warsaw Convention on liability of an air carrier engaged in international civil aviation. The second schedule harmonizes provisions of the Hague Protocol. Hague Protocol of 1955 had amended certain provisions of the Warsaw Convention. And then the third schedule harmonizes provisions of the Montreal Convention, which thereafter replaced the Warsaw Convention as far as liability of an air carrier engaged in international civil aviation is concerned. So now, Section 5 of the Act, note, does not oust the jurisdiction of any other rule, law in force in India and is not a derogation of any other law in force in India. It primarily establishes the liability of a carrier, which is expressed in liquidated damages that are paid out as compensation if a passenger who's engaged in international as well as domestic air carriage is involved in an air crash incident. Now, I'll come to one landmark case many years back. Many of you, I'm assuming, are students and would have been much younger, but I'm referring to an incident, way back in the early 2000s. There was a case, Geeta Jithani versus Airport Authority of India. Now, what had happened was that there was this girl, young child named Jyotsna Jethani. She and her family were returning by an Air India flight from Dubai to New Delhi. They had landed and they were in the course of disembarking from the aircraft. By disembarking, I mean they were on the escalator. They had got off the aero bridge and they were on the escalator to go down towards the immigration. Now, what happened that the escalator suddenly gave way and the girl got sucked in the escalator and died instantly. Right? Now, even the mother, I believe her sari or something got stuck, or the uncle, his trouser got stuck in the escalator, but the child was very young and she got sucked in the escalator. Now, help came, it came late or whatever, and by the time it happened, of course, she got sucked in, she died instantly, So, immediately, Geeta Jithani, the child's mother, after she, moved court, she moved to the National Consumer Dispute Redressal Commission. Now, before I get into more on the merits of this case, any consumer-related issue regarding air carrier liability, we file a case in the Consumer Dispute Commission, depending on which Consumer Dispute Commission, whether it is district, state, or national, would have jurisdiction based on the pecuniary and territorial jurisdiction. So coming back, so Geeta Jithani filed a case against the Airport Authority of India before the Consumer Commission, and she sued a Airport Authority saying you were negligent and the escalator didn't work. Now, Airport Authority of India immediately filed an affidavit objecting to the maintainability of the complaint, saying the liability would actually be that of Air India. Why? Because it arose during the process of disembarking. So therefore, Air India would come into play, and they referred to the Carriage by Air Act accordingly to Rule 17 of Schedule 2, which provides for carrier liability, and said it was not AI which is liable, but Air India which is liable, and Air India has not even been implemented as a party in this matter. So therefore, they said that nothing is maintainable against us because no service was rendered by AI. Now, National Commission says, okay, let's even assume if Air India was liable, the escalator had to be maintained by the AAI as per the provisions of the Airport Authority Act of 1994. Now, the service provider, the company which the escalator belonged to, was a popular company, I think, called Otis, which we see in a lot of lifts are also Otis. I think it's Otis. Now, what had happened was that the annual maintenance contract with Otis or whoever the lift or whoever the manufacturer of this escalator was, it had expired some time prior to this incident, and Airport Authority of India never ever renewed it. Now, because they never ever renewed it, therefore, the liability would fall on Airport Authority of India. So the National Commission observed that AAI was liable. Even if AAI was liable, escalator had to be maintained by AAI. Therefore, even if there was liability of Air India, it would be a joint and several liability of Air India and AAI. And non-joinder of Air India as a party could not be considered as a valid ground for defeating the claim against Airport Authority of India. So therefore, what was the final decision? National Commission holds Airport Authority of India liable and says that the embarking or disembarking a passenger, as far as that was concerned, they were required to use the airport. The airport was maintained by Airport Authority of India. Maybe yes, if you was disembarking from a staircase, normally ground handling is handled by the airlines directly, and in that's a situation, or by a third party ground handling provider. Maybe in that case, if she was coming down a staircase and some incident happened, then it would be the third party, then it would be the ground handling provider, whether it is the airline doing the ground handling or some other ground handling provider. Maybe then the airport could absolve itself of liability. But here, the disembarking was happening at the airport through an escalator, and that was, of course, maintained by AI. AI never renewed the annual maintenance contract with Otis, and that caused, there was some malfunction, and that caused the unfortunate death of this young girl. So this is one landmark case, and this appeal, the Airport Authority of India never appealed against this. So this judgment attained finality at the National Consumer Dispute Resolution Commission, which is why you would be surprised that I'm citing this as a landmark case, and this is an NCDRC judgment and not a Supreme Court judgment. So that sums up air carrier liability law prevailing in India. My colleague Tamjeed now would probably get in more in detail into the international conventions, that is the Warsaw and the Montreal and the Hague Protocol that amended the Warsaw before Montreal came in. These are important because the liability law, as far as the Indian Act is concerned, it straight away refers to these conventions, and it's very important to understand what is the international position. It's very important to understand what do you mean by disembarking, what do you mean by embarking, under international law. What do you mean by damage? For instance, say if someone's bags, if say you bought a duty-free bottle and it gets damaged because of turbulence while the aircraft is in midair, would that come as an offense? So therefore, it's important to understand in the international context, and many of these are concepts which may not have been decided domestically, but it's important to understand them from an international perspective, because if at all some issue hasn't been dealt with domestically, courts here would have to turn to international law, especially because Section 5 of the Act simply says we refer to these conventions. So it's very important to understand how does the international law look at the meaning of these different words with respect to these conventions. Thank you very much, and I pass over the mic to my host. Thank you.
Thank you so much, sir. I think that was a very insightful
I can hear
session.
you now. I can hear you now. Yeah.
Yes, sir. So Tamjeed sir hasn't joined in yet, so I think till sir
If
joins
there are
in,
any
we can take in
questions, I
the
can take them now if they have any
questions.
questions.
We'll be taking the questions coming in from the audience now. The first question
Yeah.
coming in from Arun Yadav. Sir, if the third party is damaged due to crash, but the plane is not in contracting state, then where does the third party can sue?
See, in that case, the international convention won't be liable. The third party can sue them in their local court as per whatever the local law applicable is. or if there's some treaty between the two parties.
I request the audience to post questions in the chat box. We have the next question. The Iran shot civilian aircraft. Who is liable?
Well, I think the aircraft investigation report, came out there, and one of the countries, I think, said that we mistook the aircraft. But in such a scenario, if a particular country says that, we accidentally shot the civil aircraft, it would probably be that country who would be liable, because you have to understand that, see, the Rome Convention won't be applicable, because if an aircraft is shot, it will crash midair. It gets shot midair, so only the debris fall to the surface. So, but it would probably be the country which has owed up the liability, or if at all, say, a country did not owe up the liability, then once the investigation is done, whichever country is held liable, they would be responsible. But again, all this would only work if the various treaties were signed, if the treaties involved were signed to by the parties. If not, then again it would be a matter of international negotiations.
The next question we have from Shitija. So, sir, can you guide us about how did you go for aviation law as a subject in which you actually specialized in?
Well, I've always had a passion for aviation. I actually wanted to be a pilot. I couldn't, because I have an air sickness issue and fear of heights. So because of that, I couldn't be a pilot. And that's when I decided to do law. And while I was in law, I stumbled upon this field, wonderful field of aviation law. And that's when I realized that actually I can still get back to aviation by not being a pilot and being a lawyer.
The next question coming in from Debrata. Is there any vicarious liability regarding the air crash?
Which air crash? Or in general you're talking about?
Air crash in general, I think so.
There would be vicarious liability if it can be held that somebody is liable. Like I said, as far as the Rome Convention is concerned, there is a provision which talks about contributory negligence, and it reduces the extent of liability of the operator. So therefore, if it can be proved that another party is also vicariously liable, that could be drawn in, and we could absolve the person otherwise liable to that extent, or completely if at all he isn't found to be liable.
What are your views on the possible applicable liability regime for the passengers of MH370 which went missing?
Well, here I think again it's a very, very important aspect, because the aircraft was never found, and the aircraft never landed, and therefore I think air carrier liability law would definitely I think be applicable here, because a lot of countries have a local law, that if you're not found for many years, like in India for 7 years, if you're not found, if you're not heard of, you're presumed dead. As far as this crash is concerned, even though the cause hasn't yet come, but the passengers have kind of been presumed probably dead. And if in such a scenario, I would therefore presume that the Montreal and the Warsaw Conventions, the international air carrier liability law, in short, to call it them, would definitely be applicable here. There would also be damage on the aircraft, so that would be there. Then of course, we don't know what happened to the aircraft, but say if at all one was to at some point of time, and I'm assuming it would not have, it's assumed to have gone down in water, because had it crashed on a surface, it would have been found. So I rule out the possibility of the Rome Convention of 1952 being applicable, but definitely I think air carrier liability law would be applicable. Then of course we don't know exactly what the cause is. If at all it does come out in the due course that if it ever comes out that the aircraft was shot, for instance, then even aviation criminal law would be applicable. Then we could even get those conventions in place if we get to know that the aircraft was, say, shot down and it did not crash on its own. So I think that's again something which we cannot completely rule out, because we don't really know what the cause is, and the aircraft has never really been found. So yeah, that's what I would say.
I think we can now move over to the second part of the session, wherein Mr. Syed Tamjeed Ahmad will be taking over. I request you to take over, sir. Thank you so much for joining with us.
Thanks a lot, Farhan, and my apologies for this delay. And just give me a moment. Yeah, there was some issue with my internet because of which this happened. So the topic, I don't know what Vikrant has covered, but my topic would be basically covering the international aspect of aviation liability. So just to give you a brief, because I'm not really aware what has been taken up by Vikrant as of now, I'll give you a very brief introduction about how the entire liability law works in India, internationally. We have two basic conventions, a Montreal Convention and a Warsaw Convention. Now, Warsaw has become now outdated, and the basic convention which is now operating all over the world is the Montreal Convention. Now, in liability aspect of aviation law, there are three main aspects which we always cover. What is the international carriage? What is accident? And when a compensation can be granted or can be refused. I'll cover all of these topics one by one, and then gradually we'll come to the questions part. So basically, I'll give you an example. What is international carriage? And how a jurisdiction has to be found under Montreal Convention for such kinds of acts. So according to the Article 1 and Article 2 of the Montreal Convention, it is very clear it only applies to international carriages. Now, to be an international carriage, the flight has to happen between two parties. When I say party, I mean a state. Between two states who are party to the Montreal Convention. So, for example, and one more thing which we have to see is, I'll give you an example. For example, a flight from Delhi to London is going. Now, in this case, we have to see whether India has ratified the Montreal Convention or not, and whether UK has ratified this or not. In the case where the Montreal Convention has been ratified only by one country, say India, but not by the UK, in that case, we won't apply MC. And we'll fall back to the Warsaw Convention, because Warsaw has been ratified by most nations. So you see, for the application of Montreal Convention, it is very important that both the countries must be party to that convention. But that is the case in one-way ticket. In a return ticket, the entire thing changes. So for example, a flight you book, say from Delhi to London, and after 20 days from London to Delhi, and something happens on your flight from Delhi to London. Say it happens at the time when the aircraft had landed at the London Heathrow Airport. Even at that moment, the jurisdiction will not be in UK. The jurisdiction will come back to India because it's a return ticket. So in a return ticket, what we have to see is so in a return ticket, the point of departure and the point of arrival are always same. So if you depart from Delhi, your arrival, the ultimate arrival, will also be Delhi. And that is the reason in Montreal Convention or for any convention, when we say return ticket, the country from where you boarded, that is the country which has to be seen. So you don't need to see whether the other country from where the flight had gone, whether that country is following Montreal or not. That is the basic point here. Now, once you have gone through the point of carriage and it has been established that this journey is covered by Montreal Convention, a compensation can only be paid when you prove that there was an accident. Now, accident has been defined, or compensation has been defined under Article 17 of the Convention. So what is accident? I'll give you a very funny example. Say, for example, you're sitting in an aircraft and somebody is placing a bag over the upward bin. And while placing that bin, in that bin, that briefcase or that suitcase falls upon your head and you get an injury. So for most people, they will say it's an accident. But under aviation law, it will not be regarded as an accident. And the reason is, for an accident to happen in aviation law, the event should be, it should be, just give me a moment here. Yeah. The event should be unpredictable and it should have caused certain physical injury. Now, the ruling here is this, that when you are sitting in an aircraft, it is quite predictable, it is quite possible, it is quite contemplable that a briefcase or a baggage might fall upon your head. And that is the reason this prediction part that comes into play. So any act, any incident which could have been predicted, that will not be covered as an accident. So for an accident to happen, there should be an injury. It should be a physical injury. It should have happened during the course of the flight. And secondly, it should be unpredictable. So if any incident which is predictable, that event will not be covered into the definition of accident. Similarly, in aviation law, there is no concept of mental injury or mental damages. So, for example, a person says he has suffered mental trauma because the flight was going through a very severe turbulence, and he saw death is very near. Even in that case, mental trauma will not be compensated, because the prime requirement under aviation law is that your mental trauma or your mental injury will only be compensated if there is a continuing or there is a ancillary physical injury. So without physical injury, there can be no sort or no type of mental trauma. And the reason why the courts have not allowed this to happen is because to protect the industry. Because when you are flying a flight, an aircraft, it is quite possible you might pass through a rough weather, you might pass through a turbulent weather, and you might be passing through a phase where the outcomes of the flight might not appear very good. You might think, okay, this is your last flight. But that's not the case in most cases. That is the reason that the law says until there is certain combination of physical injury, there cannot be a compensation for mental injury. That is the basic concept. So the basic takeaway point here is this: an accident has to be unpredictable. It must happen in the course of the flight. And secondly, there should be a physical injury. Mental injury will not be compensated. Now, another aspect which we have to often deal in aviation liability is the aspect of cargo. Now, in cargo, Article 18 of the Montreal Convention, it deals with the topic of cargo. The basic point here is this, that the liability of a carrier, if you see your check-in baggage, they always say that the liability is fixed. So the liability of a carrier has been fixed in the Montreal Convention. So to break the liability, either you prove that you were taking a sort of, you had declared your good. And I'll give you a practical example. If you go to any airport check-in counter and you say you want to declare this good, that it's a costly good, they won't allow that to happen easily. And the reason is this: the logic is, if your good is so precious, please ensure that. So the liability is not breakable easily. The liability in the cargo cases is fixed to certain SDRs, and to break that SDR level, it's a difficult task to prove. Moreover, if the coach now, an example would be, you book a ticket for cargo, and that cargo was booked by Lufthansa Cargo, for example, or any cargo for that matter, any aviation cargo matter. And due to that cargo, or due in that cargo itinerary, a certain point, a certain area, or certain phase also involved road transport, or also involved inland water transport. So no matter the ticket or the cargo was originally booked through an airline, but as per airline's policy, after a certain point, the cargo would be transferred using what? It would be transferred using some other means which is not an air mean. In that case, if something happens to the cargo, a cargo is damaged during the transport, which is not during the air transport, rather on road transport or inland water transport, even then the airline would be liable under Montreal Convention, provided the airway bill was issued as one by the airline and the issuing company. Originally, it was issued as an airway bill. So just the fact that the cargo was being carried on road, it does not takes away the jurisdiction of Montreal Convention, provided the original airway bill was issued by an airline which was meant for air transport. So that is something. There's a very famous case in this area also, in which certain hard disks were imported from Japan and they had to go in US, if I'm not wrong. And the entire journey had 80% of aviation package and 20% involved road and water transport. So nothing happened during the aviation transport aspect, but during the transport by road, there was an accident. And the plea which was taken by the airline was that this has happened through a third party, and therefore the airline cannot be held liable here. But the court held, since the airway bill was issued by you and the airway bill was for the entire journey starting from Asia till America, so it is irrelevant whether in the mid of the journey you choose to take a road transport mode and not an air mode. So that's a basic point which you have to see here. Another important aspect of aviation liability, which I will cover with you, is in Montreal Convention, the payment is not in dollars or in US or in pound or in euros. The payment is in SDR. SDR is special drawing rights. It's basically a combination of 5 currencies. If I'm not wrong, they are Japanese yen. Japanese yen is the pound, euro, and dollar, and it's also the Chinese currency. These 5 currency make one SDR. So the payment for compensation in aviation happens through the concept of SDR. Another issue which as a lawyer you'll always see, is the conflict between Consumer Protection Act and Montreal Convention. So I don't know what was covered by Vikrant, but I'll give you a simple example that our consumer forums, for example, if somebody's flight got delayed, so that person has a right to invoke the relevant car or the relevant aviation law in India. But if that person chooses to invoke Consumer Protection Act and says that the delay of flight is basically a deficiency in service on part of the airline, therefore he is seeking compensation under the Consumer Protection Act, that will be a conflict case. Another area of conflict which you will see, or which you can see, is the issue of cargo. So if somebody invokes deficiency in service clause under Consumer Protection Act, because in COPRA there is no limitation of liability. The liability limitation only comes under the Montreal Convention. So if a person is invoking Consumer Protection Act, then the point of consideration here is whether the limits of liability which have been fixed in Montreal Convention, will they apply in this case or not? What the practice has been, and what if you'll find that the district forums of consumer or the state forums, they generally are more hesitant towards Montreal Convention, and they feel it is much more easier for them to apply the normal consumer law. It is here where we always see that there's this issue which is coming up, because the broader consumer law is different, but then we have a different liability law for aviation, and this conflict is something which IATA, for that matter, has been raising for a long time. But again, this conflict has not been settled yet. So that is my basic presentation. I'm really sorry I had this terrible issue with my internet, so I'm still not aware what was taken up by Vikrant. But any questions which you have on the concept of aviation liability, consumer law, or any matter of aviation law, please feel free to ask. I'm more than happy to take your questions, and I'll try my best to give answers possible. Thank you.
Thank you so much, sir. I think that was a very insightful session too. We have questions coming in from the audience. I would also like to remind the audience that they can put forth the questions in the chat box. The first question coming in from Srinivasan Raman. In case of two airlines involved, for ex-Air India Delhi to Paris and Paris to Buenos Aires by Air France, the situation occurs on Air France second leg. In this situation, which law shall prevail?
Okay, it's a good question to ask. So the situation here is from Delhi to Paris and from Paris to Buenos Aires. And situation occurs on Air France. So you have to see whether the ticket was booked as a single ticket or it was booked as an interline ticket. So if the ticket was booked, I mean, if the code which was being used by the Air France flight was an Air India code, that is, it was a code share agreement, in that case, the contracting carrier is liable. So we have two carriers, a contracting carrier and an actual carrier. Actual carrier is Air France in this case, but your contract or your contract is basically with Air India. I'm assuming that. So if your contract is with Air India, in this situation, the liability will be fixed on Air India. Obviously, the Air India can claim indemnity from Air France in that case. But again, on the part of jurisdiction, the question can be settled either in Buenos Aires or either in Delhi. Second part would be that you have to also see that we have to see whether Delhi and Buenos Aires and this country where you're going, these two countries have ratified MC or not. If they both have ratified MC, in that case, MC will prevail. But if they have not ratified MC, in that case, WC or the Warsaw Convention will prevail. So I guess I have answered your question. So remember, it's the actual carrier and the contracting carrier.
The next question, does escalators come under aviation law?
It's a good question to ask. So basically, I'll give you an example. What happens here? The logic of the law is, see, every law has certain logic. And the logic in aviation law is, if your actions are under the control of the airline, say for example, you are disembarking an aircraft, and till a certain point, there's an aero bridge, and you walk. Till the point you can go, till the point you cannot apply your mind. You have to follow the instructions of the airline. Till that time, the liability is with the airline. The moment you can either go left or you can go right. So when you have walked the aero bridge, you reach to a point where you can go either left or right. In that case, the liability, if something happens at that point of time where the instructions of the airline was not required to be followed, in that case, the liability will be with the airport, not with the airline. Another example would be you're standing in the queue for check-in. So at that very point where you're standing for the check-in, you cannot go right or left. You have to follow the instructions of the airline. In that case, if the roof falls, unfortunately, on you, the liability is on the airline, because the logic here is you are under the control of the airline. But the moment you have crossed the check-in point and now you are under the control of the airport, at that time something happens, the liability is with the airport. So that is the basic difference you have to understand. So the control has to be seen. When the incident happened, who was under control? If the control was with the airline, then airline is liable. But if the control was not with the airline, in that case, the liability has to be seen from the aspect in that area which airport or which authority was having control.
Aishwarya Hormus wants to ask, does intention play a vital role for a suit under the Montreal Convention, or is the focus on the act as such only?
I don't know why this question has been asked. Intention is an aspect of criminal law, right? And Montreal Convention is civil law. In civil law, there is no concept of mens rea. We only see actus reus. So if actus reus is there, you will be compensated. The concept of intention is only in criminal law. So I believe that should answer your question. Obviously, if you go for Montreal Convention of 2014, which is the criminal aspect of aviation liability, their intention has to be seen. For example, if somebody is trying to, or if you see unruly behavior, even in unruly behavior, the concept of intention is not important. What is more important is the act. If the act which has been committed by the party or by the airline, if it falls within that category, the person can be liable.
Another question coming in from Tamanna. If a person dies of heart attack due to heavy turbulence at the time of the takeoff, then who shall be liable?
Uh, I haven't come across a case in my very small, I must say, very small career these days. But if a person dies of heart attack, my legal mind says um, the airline will not be liable. No, it's something death can happen anywhere. I mean, if the death happened due to certain act of the airline, for example, there was some issue with the aircraft that the pressure was not right or the oxygen level was not right, then you can hold the airline liable. But if you suffer a heart attack because of turbulence, no, I don't think airline will be held liable. No, it won't be.
Looking from a law student's point of view, a law student wants to ask, is sports law or aviation law, which is better in terms of a career aspect?
That's a nice question to ask. I believe law as such is a good career option. If you are loyal to law, you're good. I always say that you can be an aviation lawyer, you can be a sports lawyer, you can be an outer space lawyer, but before everything, you are a lawyer. Know the law. If you know the law, you can hop on from aviation to sports so easily. It's not that difficult. So I would say know the law and be loyal to your subject. That is the key to success in this field. Okay. Am I audible? Can you? Farhan, I believe it's not working. Hello.
I'm really sorry, sir. There was a network issue on my
Not an
side.
issue, not an issue.
Yes, sir. We'll move on to the next question.
There's some question I was reading on this why the word space is used
Mhm.
in aviation and space law, right? Somebody named Ishti Jaz, if I'm not wrong. So I want to answer this question. So that would be, air and space law are two different disciplines of law.
Surely, sir.
Air law is totally different. Space law is totally different. The basic concept of air law is sovereignty. So a sovereign nation has full right over its airspace. Outer space, there is no concept of sovereignty. Now the reason why we link and we say in space law, because uh, airspace and outer space, I guess that's the logic here. But from an aspect of principles of law, I believe the logic or the principles of aviation law are different. The principles of space law are totally different. So, but yeah, I believe there are certain more aspects which connect them, but don't confuse that. Aviation is a different set of law. Space is a totally different set of law. The principles on which they are based is mostly different. And the mother of aviation law is maritime law. the concepts of aviation law have been borrowed from the concept of maritime law. So I guess that should answer your question, Mr. Whosoever he was. Yeah, we can. Something was like that. Yeah. You can go ahead.
So we'll take another question. Which is the best university to do aviation law? I'm an airline safety instructor looking forward to understand the legal side in depth.
I would say Leiden. I'm from there. No other answer. You can also try McGill. McGill is also very good. In India, we have Nalsar. Nalsar is also doing good. If I'm not wrong, even there's some more university in Bangalore, which they have certain courses in aviation law. But in India, the best university is Nalsar. Okay. Next, any?
I think with this we can come to this to the end of this very insightful session.
Okay. And again, I'm so sorry for this delay and for this entire hookup. It was like my entire system froze. So I'm really sorry for that thing. And if you have any other questions, please feel free to mail me at sayed.tamjeed@sarins.org. I'll be more than happy to take your questions and I'll be more than happy to answer any query which you have, which pertains not only to aviation law, but to law in general.
Thank you so much, sir. Thank you so much for joining with us. Thank you all for attending the session.